Hello, everybody. I'd like to welcome you all to today's event, Progress Imperiled, the Healthcare Law, its Implementation, and Constitutional Challenges. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. ACS is a network of lawyers, law students, policymakers, and judges who are working to restore the vision of the Constitution as a protector of human dignity, of individual rights and liberties, of genuine equality, access to justice, democracy, and the rule of law. As we close in on the one-year anniversary of the passage of the Affordable Care Act, the future of this landmark healthcare reform legislation remains in question. District court decisions from 5 federal judges have split on the constitutionality of the law's mandatory individual coverage provisions, and there have yet been no appellate decisions. At this critical juncture, and as the Department of Justice awaits Judge Roger Vinson's clarification of his Florida opinion, we are here to discuss some very important questions, including what are the merits on either side of the constitutional debate? What is the status of the litigation? What are the jurisprudential stakes for the federal government's power to address pressing national problems? How is the law's implementation going? And what is the effect of the uncertainty caused by the litigation on American businesses and the lives of the American people? Our panelists today will discuss these and many other critical issues. But we are deeply honored to have a keynote speaker who has been deeply involved in health policy and who played an instrumental role in helping to pass the Affordable Care Act, former Senate Majority Leader Tom Daschle. And while you all know it would take me an extremely long time to enumerate his many, many, many accomplishments, I don't want to take away time from his talk, so I'm going to say briefly that Senator Daschle is now the Senior Policy Advisor at DLA Piper, where he serves as a member of DLA Piper's Global Board and advises clients on an array of domestic and international issues. He has a storied career in government. After 8 years in the House, he was elected to the Senate in 1986 and became one of the longest-serving Senate Democratic leaders. He's been published widely on healthcare matters, including books such as Critical: What We Can Do About the Healthcare Crisis, and most recently, Getting It Done, which is an intimate look at the passage of the healthcare reform legislation that we discuss today. And as someone who had the extreme pleasure and honor of serving on his staff in the Senate, I'm really delighted to be able to welcome him here today. Senator Daschle.
Caroline, thank you very much for that generous introduction, and thank you all for your warm reception. I appreciate very much the fact that so many of you have taken time out of your busy schedules to be participants in this important discussion today. Carolyn, as she noted, was a very valued member of my senior staff for a number of years in the Senate when I was leader, and I am grateful to her for her extraordinary service to her country and to the U.S. Senate, and I'm delighted to see the remarkable leadership that she's provided ACS now that she has become the executive director. It goes without saying that this is a transformational moment in American history with regard to health policy. I would say it equals, if not exceeds, the importance of the creation of the Federal Reserve in 1913, Social Security in 1935, and certainly Medicare in 1965. And as transformational as this time for health is, it's also important to note that the basic character of our healthcare marketplace remains unchanged. We're the only industrialized country in the world that doesn't have a healthcare system. We never have, may never have one in the future. We have instead a collage of health subsystems, many of them with extraordinary stovepipes that don't interrelate very well at all, and therein lies part of the problem. Not only is it a collage of subsystems, but it's a hybrid of both public and private systems. And as we continue to analyze our circumstances involving our healthcare mechanism and marketplace today, there is a widespread consensus on what the problems and challenges are. A consensus on the problems relating to cost, a consensus on the problems related to quality, a consensus on the problems related to access. There's even a consensus on the reasons why most of those problems exist today. And I would argue that I have little debate or argument with regard to my assertion about what the goal of health reform should be. As I speak to audiences around the country, I marvel at the degree of virtual unanimity about the succinctly stated goal that we really want to see a high-performance, high-value healthcare marketplace based on greater access, better quality, and lower cost. That's as succinctly and aptly stated as I think I can provide. And yet that goal is subject to a great debate about the direction our country should go with regard to health, in large measure because of the divisions within our country on the role of government. What is the appropriate role for government today in healthcare delivery, in all aspects of providing high-quality healthcare with high performance as the goal so states? Well, that is, at its heart, the core of the debate that goes on even today after enactment. On March 24th, we'll celebrate the first anniversary of the enactment of the Affordable Care Act. I would argue that this anniversary is nothing more than yet another reminder of the tremendous work that we have left to do. That when we passed the ACA, basically all we did was provide the means, not the end, of healthcare reform implementation. And that really we're only on about the 30-yard line if this were a football field, with 70 yards to go with regard to progress on an array of challenges affecting cost, access, and quality as we go forward. And even if all goes well, it would be my expectation that at minimum it will take a generation before all of this can be effectively implemented to the satisfaction of those with the vision to enact the legislation in the first place, with the core work required over the course of the first decade. Well, post-enactment will probably play itself out on 4 very distinct levels. And each of these levels will have a lot to do with the success that we will witness and experience as we go forward with the enactment of this important legislation in this transformational time. And those 4 levels include the administration and regulatory level, the state integration level, the policy level, and the legal and constitutional level. All 4 of those are very interrelated and integrated in many ways, and how one plays itself out will certainly affect in many respects how the others are affected as well. Let me talk about the first, the administrative and regulatory level that has now been underway for a year. It really has 3 major components. The first component is insurance reform, and we've seen already the extraordinary change that has been articulated and formulated as a result of the passage of ACA on March 24th. Multiple loss ratio now for the first time in history at the national level. Patient protections, including the end of annual limits and lifetime limits, the end of pre-existing conditions, and the screening of potential beneficiaries as eligibility is considered for insurance, and ultimately the ramp up to the biggest change of all in 2014, and that is the creation of state exchanges, new marketplaces for health insurance that will transform the way insurance is bought and sold, transform the way we look at our ability to access insurance as well as healthcare itself. These exchanges will be critically important, and the ramp up and the implementation of insurance reform is key, is absolutely essential to getting this job done right. And I must say I give high marks to the administration for their work in this first phase of implementation in insurance reform. The second is payment reform. That is every bit as important in many respects, and there we will see as our primary goal a movement away from a volume-driven system to one which is value-driven. Value-driven with the end of fee-for-service as we know it today, with far greater transparency, far greater reliance on health information technology to accommodate that transparency, with a substantially different approach to payment based on experience, with globalized, bundled, and perhaps in some cases even capitated approaches to payment as we go forward. There is far less prescriptive language in the law involving payment reform, but far greater jurisdiction and authority and discretion given the Secretary as this payment reform responsibility unfolds over the course of the next decade. The third component of the administrative and regulatory approach at the first level is delivery reform. And there we see a movement away from the current practices of an emphasis on illness to one devoted much more to wellness, creating paradigms for wellness unlike those that we have ever had before. Changing the pyramid, as I like to call it, from top to bottom to top. That is, every society has health care in the form of a pyramid. At the base of the pyramid, you have good primary care and wellness, and as one works their way up, you get more and more sophisticated until at the very top you have the most technological applications to health. Every society starts at the base of their pyramid and they work their way up, oftentimes until the money runs out. In the United States, we start at the top of the pyramid and we work our way down until the money runs out, and unfortunately it runs out. Too few people get good wellness care today because we have never focused on the bottom of the pyramid. Delivery reform for the first time will give us that capacity to produce the kind of wellness approach to good health that we've needed for a long time. But that isn't the end of the story. Delivery reform also means better coordinated care among chronic illness environments, far greater than we have today. 75% of the illness-related work that we do in health today is chronic illness-related. We need to find ways to tear down the stovepipes, to coordinate our care more effectively. And accountable care organizations and medical homes will provide us with an opportunity to do that. We need to emphasize best practices, evidence-based approaches with comparative effectiveness research, delivery reform, and that component is certainly going to help us do that. And ultimately, our goal is to eliminate those sources, those causes of unnecessary care, including defensive medicine, proprietary medicine, where doctors have a harder and harder time drawing a distinction between businesses and practices, and market-driven care, where people see things on television they like and demand it of their doctors and get it. The fraud that exists today, and all of the unnecessary care driven by high administrative costs. About 1 out of every $4 or $5 in our whole healthcare marketplace today is driven in large measure by excessive paperwork. We can deal with those, and delivery reform will allow us to do that. So that's the first tier, a very important tier with incremental steps over the course of the next 10 years. We've taken the first year's steps, and I think we've done so largely very successfully. The second level is the state integration level. And there we have a myriad of different scenarios depending on the state, the circumstances, and in large measure, the governor's position on health reform to begin with. So far, 48 out of 50 states have participated in the early stages of the state integration. And those two who have held out, Florida and Alaska, have actually had the temerity to ask for resources in spite of the fact that they're holding out. But nonetheless, we all recognize that states are beginning to take on these responsibilities at a time of great budgetary pressure, extraordinary difficulty in virtually every state in the country today. And it's with all of that budgetary pressure that these new responsibilities are ones that present great challenges to states, and I think it's important that we not only empathize, but that we provide the kind of support necessary to ensure that they can do this successfully. That will take resources, it will take support and coordination and cooperation, and it will certainly take a degree of flexibility as we go forward, especially in the early years, that will be necessary for us to adapt to circumstances that recognize the differences between a Utah and a New York, or a South Dakota and an Ohio. And so it is critical as we go through this stage that we provide the maximum degree of flexibility and partnership. It is my view that the 3 Ps, preparation, partnership, and pragmatism, are the 3 key words in making a successful state integration a reality. I think the primary leverage that the Secretary will have as she continues to work with the states, however, is the realization that should they refuse to participate, or should they be unable to participate, that she has the authority to step in and do it on behalf of the people of that particular state. That leverage will be extremely important as this state integration process continues. So that's the second level, effective and successful state integration over the course of the next decade. The third level has to do with the policy and the legislative agenda. And in large measure, in my view, that level involves mostly reactive work rather than proactive work for those of us who strongly believe in the ACA. We've seen a debate about the role of government continue even after enactment, and we'll continue to see that as it plays itself out with the legislative battles on the Senate and House floor over the course of the coming months in the 112th Congress. We've already seen the debate about repeal. It passed in the House. It will continue to fail in the Senate. That is going nowhere. We've begun to see the debate about defunding. And again, there was some success in the House. I believe that they will have great difficulty defunding in the Senate. Amendments have been offered. One has passed, the so-called 1099 amendment that allows for greater transparency with regard to transactions over $600. That most likely will pass in some form. That is the elimination of that requirement. Unfortunately, it's a $17 billion hole over the next 10 years. And I'm not as sympathetic as some about the need to do this, but nonetheless, it is likely to become law. But one of the few amendments that I would expect we will see ultimately as a successful legislative effort over the course of the next 2 years. Expect to see many more amendments having to do with the mandate, having to deal with the Independent Payment Advisory Board, and a whole array of other provisions, some involving Medicaid, that will continue to be debated and offered in both the House and the Senate. The policy and legislative levels, in my view, while important and should never be minimized, are probably the least impactful as we go forward, in my view, in large measure, because I don't believe, so long as we have the requirement for 60 votes in the Senate and a Democratic president, that the legislative efforts to significantly alter the Affordable Care Act will be successful. The final post-enactment stage is the one that perhaps this conference is most interested in. And I am very impressed with the very distinguished panel that will be discussing this level in a far more thorough and complete way over the course of the next hour and a half. But let me simply add a little bit to what Caroline has already noted with regard to this particular level, that is the legal constitutional question. 26 states have now challenged the constitutionality of the ACA. Most of their focus has been centered, of course, on the dispute involving the authority to create legislation requiring an individual mandate to purchase health insurance, although some of the focus has been on the expansion of Medicaid as well. I thought Larry Tribe's characterization of these lawsuits was particularly apt and accurate. Writing recently in the New York Times, Professor Tribe called them political objections in legal garb. I like that phrase, political objections in legal garb. Well, they have plenty of legal garb, and they are taken seriously, far more seriously today than they might have been a year ago. And even though they are political objections, I think we have to treat them as seriously as I know this organization has, as well as the courts themselves have demonstrated. So far, the lower courts, as Caroline noted, have ruled in 5 cases. Unfortunately, in my view, the rulings have all fallen along party lines. The current score is 3-2, 3 in favor of constitutionality, 2 in opposition. And I have every expectation, as I know most of you do, that this matter will come before the U.S. Supreme Court perhaps as early as next year. And while it's easy to assume that the justices will be political actors rather than legal analysts, I think Professor Tribe makes 4 very compelling points that I would simply reiterate this afternoon. The first is that since the New Deal, the Court has consistently held that Congress has broad constitutional power to regulate interstate commerce, including those matters involving individuals' economic choice. And so there is an ample and a very well-developed record with regard to court decisions on other matters involving the continued expansion of the Interstate Commerce Clause. He notes that this matter, secondly, is little different than Social Security, and that in 1982 the Court unanimously recognized that it would be, quote, difficult, if not impossible, to maintain financial soundness if people could opt out. I think it's very important to note that it was a unanimous decision, and it was based on the fiscal soundness of Social Security, much as the whole question of fiscal soundness is considered today as we consider the whole architecture and infrastructure of health delivery in the United States. Third, he asserts that there is an illusory distinction between regulating activity and inactivity, and that the conscious choice not to participate in the national health marketplace has serious economic consequences, just as the Court noted in 1982 in the Supreme Court decision. And fourth, Professor Tribe argues that with the exception of Justice Thomas, both the conservative and the progressive justices on today's Court have been remarkably consistent in past cases involving similar principles. Well, no one can predict how this level or any of the other 3 levels will play themselves out over the course of the next couple of years, or that for the matter of the next decade. But this transformation goes to the very heart of the reason of the existence of this organization. And I believe it's one of the primary reasons why so many of us should care so much about the future as we consider it in this context. Winston Churchill once remarked about the United States that this country will always do the right thing after it has exhausted every other possibility. Well, I think we've virtually exhausted every other possibility when it comes to health reform. I think we've exhausted every other possibility when it comes to access, cost, and quality. We've exhausted every other possibility with regard to the challenges constitutionally. Now is the time for us to put it behind us and to get this job done. This is a fight for the equality and the liberty of all Americans and their moral right to health security at long last. Thank you all very, very much.